Now, lawmakers from both sides of the aisle are looking into a new form of government snooping. The feds are reportedly using fake cell phone towers to collect information on criminal suspects. But these simulators may also be picking up private cell phone information. So what are the constitutional implications here? Let's bring in our legal panel, Attorney Richard Roth, criminal defense attorney E.J. Abt. Start with you, Jay. In this sense, it makes perfect sense that if you're a criminal or a fugitive and the police want to figure out where your cell phone is, they have a fake cell phone tower, picks up everything, and does that. But when all of a sudden you start picking up the information of hundreds, if not thousands, of other cell phones in that area, that seems to be troubling, at least.
You know, I successfully defended a murder case back in October where the key issue was cell phone tower triangulation technology and these stingrays. We call them stingrays, which are these imitation cell phone towers the government uses to track people in real time. And what we found out through that trial was fascinating in terms of the government's ability to not just collect data about the accused that I was representing, but other people who were even near that cell phone tower. They're using it to get the historical data based on where anyone is located at any given time. They can get text messages, they can get phone calls, and they're doing a lot of this without a warrant. They're doing it because the government is so in bed and so closely tied to these cell phone carriers. Sometimes they're just sending them a letter or sending them a subpoena, and it's fascinating how much they've expanded their ability and their power to govern and look at regular citizens like you and I and what cell phone data usage we're using in terms of where we're located, who we talk to, what our text messages are, and it's very disturbing.
Richard, I want to let Richard jump in here in the sense that a lot of folks would say, well, if you don't have anything to hide, what do you care if the government knows where you are, where your cell phone is? But at some level, it's kind of fundamentally bothersome that you can be walking down the street and simply by virtue of the fact that you're there, the government is then snooping on your location and your text messages and everything else.
It is fundamentally bothersome. The issue is there's a conflict. The conflict is between the Fourth Amendment and what's called the reasonable expectation of privacy and the government's ability to track down fugitives, criminals, terrorists, anyone who's of public harm. That's the conflict. And what's happened in today's day and age, in light of the technological advances and the drones and the fact that there's a camera on every street corner, your reasonable expectation of privacy has been reduced. It's 2015. We're in a very different world than we were 10 years ago. When I walk out the door, there will be cameras looking at me. There will be people that can hear my cell phone. So do I have, under the Fourth Amendment, a reasonable expectation of privacy if I'm walking around in the public? That's really the issue here. And some would argue that reasonable expectation has been shrinking and shrinking and shrinking. And if I'm on the phone and if I'm in the public, then some would argue that I should know that anything I say or do can be heard and or seen.
Jay actually argued this case, though. Take us through a little bit more in terms of how this argument worked out in this murder case.
So we actually had a client who was being accused of a murder, and the government used his cell phone to track him to various locations, alleging that he was involved in the murder. Now, ultimately, we were able to acquit him of that because just because you have a cell phone with you doesn't necessarily mean you're committing a crime. And what the government is doing is not only are they looking at the accused, the person they suspect, but they're looking at other people as well, because then they're taking the phone calls off of that target's cell phone, and they're looking at the data from other callers that they send and receive calls to, and they're doing it often without a warrant. This year, the U.S. Supreme Court decided Riley versus California. It was a groundbreaking U.S. Supreme Court case that said the government can no longer, if they have your physical cell phone, look inside the cell phone without a warrant. However, the court really needs to expand that decision. Mr. Roth is right. The reasonable expectation of privacy has diminished, but we should fight back against it. We need to expand what our privacy rights are, and the Supreme Court should expand Riley versus California to include not only cell phone tower data, but this stingray technology, so that the government isn't tracking people in real time without their knowledge and without their consent.
It's incredible now to try to apply a document written in the 1700s to modern-day technology. The challenges are vast, and that's why we have folks like you guys to break it down for us. Richard Roth, E.J. Abt, sure appreciate you guys being here. Your insight. Fascinating debate. Thanks, fellas.
Thank you.
Happy New Year.
Thank you. Happy New Year.